Hi, everyone. Thank you for joining us today for Hunton's webinar on business continuity and COVID-19 from a GDPR perspective. If time permits, we'll address questions at the end of the presentation. Otherwise, feel free to send us your questions by email. Please also note that we are recording this webinar and will make the recording available following today's program. I'd like to take a moment to introduce our two panelists for today. David Dumont is a partner in our firm's Brussels office. David assists clients with various aspects of EU privacy and data protection law and is well-versed in GDPR developments. He also advises clients on cutting-edge privacy and data protection law questions, such as those related to the use of employee monitoring technologies and mobile applications, which, as we know, are topics at the forefront of COVID-19 privacy issues today. We also have Anna Pateraki joining us. Anna is a senior associate in the Brussels office and focuses on global and European data protection law, including privacy compliance programs, binding corporate rules, and data breaches. Anna has extensive experience advising on GDPR compliance and German-related data protection issues.
Thank you for the introduction, Catherine. And before diving into the presentation, just a few words on our team. At Hunton and Kurth, we have a team of nearly 50 privacy and data security professionals in our offices in the States, Europe, and Asia. We assist clients from different industry sectors with all their privacy and data protection needs. And for those of you who would like more information on our firm and the team, please go and have a look at our website, huntonak.com, on which we now also have a COVID-19 resource center where we provide constant updates on legal and business challenges related to the pandemic. For the latest developments in the field of privacy and cybersecurity, you can also visit our blog at huntonprivacyblog.com or follow us on Twitter. Okay, with that, let's take a look at the roadmap for today's presentation. The COVID-19 outbreak and the measures that have been taken all over the world to fight the spread of the virus have presented and are continuing to present unprecedented challenges for everyone in society. Although the focus should, of course, be on ensuring people's safety and health, privacy should not be lost completely out of sight. The privacy community and regulators have been very active in identifying and analyzing the privacy issues related to the new data processing activities that are resulting from measures that are taken in response to the pandemic. To start the program, I will be giving a high-level overview of the COVID-19 related privacy and data protection issues that everyone has been focusing on so far. And after that, I will turn the floor to my colleague Anna Pateraki, who will take you through some of the issues that privacy professionals should be thinking about during this crisis situation from a business continuity perspective. She will be addressing some of the challenges that companies are facing in connection with crisis management measures that have been rolled out. And after that, she will also highlight some of the practical considerations you should be thinking about in terms of keeping the privacy program up and running during the lockdown period we are all in today. Let's now start by taking a quick look at the COVID-19 related topics that EU data protection authorities have been focusing on today. Many data protection authorities around the globe, including in the EU, have issued guidance to assist both the public and private sector in finding the right balance between taking effective measures to reduce the spread of the virus while limiting the impact on individuals' privacy as much as possible. Almost all, if not all, data protection authorities at national and EU level have issued COVID-19 related guidance or statements since the outbreak of the virus in Europe. The guidance issued by different data protection authorities varies both in form, in scope, and in actual substance. In terms of scope, some regulators have limited their guidance to informing the public and companies about the impact COVID-19 has on their own operations. For example, what happens with hearings in administrative proceedings that were already scheduled or pending decisions and so on. However, most data protection authorities in the EU have focused their guidance on a number of key questions related to the processing of employees' and visitors' personal data that is necessary to reduce the spread of the virus. A second wave of regulatory guidance that we've seen was focused on the data protection risks and challenges that are related to the confinement measures, and in particular, addressing the various risks related to remote working. And over the past weeks, regulators' focus is really shifting towards the lawfulness of tracing apps, which, for example, involve the processing of location data of people's mobile devices to monitor compliance with confinement measures and to prevent the spread of the virus in the post-lockdown era. So these are, at a high level, the topics that have been on the radar of regulators. But I assume that there is more guidance to come as confinement measures continue to evolve and data protection issues resulting from them become more clear. As mentioned already, there is a certain degree of consistency in the topics addressed by the various data protection authorities to date. Most data protection authorities have focused their initial COVID-19 related guidance on questions around the lawfulness of certain new and specific data processing activities that arise in connection with measures that private companies are taking in response to the pandemic. For example, can private companies require their employees to provide data about their or their relatives' health through questionnaires or by conducting temperature or other diagnostic tests? Can they share this information about potential infections with other employees, and if so, in which level of detail? Can employers also collect personal contact details of their employees for the purpose of informing them of a potential risk of infection? Can employers ask questions around travels to risk areas and so on? Although there's certainly consistency in the topics that data protection authorities have covered so far, the question really remains whether there is the same level of consistency in their actual guidance on these topics. And luckily, there is at least a certain level of consistency in the guidance issued by different EU data protection authorities, in the sense that they generally take the view that the GDPR does not prevent the processing and disclosure of personal data necessary to fight the COVID-19 pandemic, but that even in an emergency state, the main data protection principles must be respected. This means, first of all, that for any data processing activities that are initiated in the context of COVID-19, companies must ensure that one of the legal bases under Article 6 of the GDPR, and if sensitive data is involved, Article 9 of the GDPR, must be satisfied. Most data protection authorities in the EU have indicated in their guidance that the legitimate interest ground may be a relevant legal basis to legitimize COVID-19 related data processing activities. To the extent that sensitive personal data is involved, they refer to the necessity of the processing for companies to carry out their obligations under local labor law to ensure a healthy and safe workplace, as well as the necessity of the processing to protect individuals' vital interests as available legal bases to legitimize the processing of sensitive data. With respect to mobile location data processed in the context of these tracking apps, which is basically subject to the e-privacy directive, data protection authorities generally take the view that such data should be made anonymous, and where that is not possible, consent will need to be obtained. In addition to making sure you can rely on a legal basis for your data processing activities, data protection authorities stress the importance of ensuring that only strictly necessary data is being processed and that individuals are provided with clear and transparent information with respect to the processing of their personal data. Furthermore, given the often sensitive nature of the data involved, data protection authorities also stress the need for information security measures which are appropriate to the risks related to the processing of this type of data. Despite the consistency in the general message of the data protection authorities, there are significant differences in how national data protection authorities have interpreted the exact application of these principles to the various data processing scenarios that I've already discussed. There's, for example, a significant difference in the guidance when it comes to the question whether or not, and if so, to what extent, employers can require employees to provide information about their health status through questionnaires. Some DPAs indicate in their guidance that mandatory information collection is justifiable given the emergency situation we're in today. Others have taken the view that such information can only be processed if it's given on a voluntary basis. And others, such as the Dutch Data Protection Authority, have taken a very stringent view by saying that employers should typically not process any health information of employees. So although companies that are operating in various EU jurisdictions will be able to develop to a certain extent a pan-EU approach to their COVID-19 related processing activities, there may be a need to tailor this approach on a country-by-country basis to take into account those local requirements and differences in guidance at local level. So with that, let's now turn our focus to some of the data protection challenges related to crisis management measures that have been taken to ensure business continuity during the COVID-19 pandemic. And although the priorities that each company sets in terms of crisis management depend to a certain extent on its business model and the impact of the COVID-19 lockdown on its particular business, there are a number of topics that are likely going to be important for every company out there. And the first one we want to touch upon is the identification and preparation for specific cybersecurity challenges in connection with the lockdown situation. We have seen also with our clients that companies face particular cybersecurity challenges in relation to the COVID-19 crisis. During the lockdown period, hackers stay home too. This gives them a lot of time to do what they do best, and that's searching for and taking advantage of vulnerabilities in companies' IT systems. And the lockdown does present some significant information security challenges. Employees working remotely access, send, and receive significant amounts of sometimes sensitive personal data on their home network, their company laptop or their personal laptop, their mobile devices, and so on. Furthermore, in a good faith attempt to continue to perform their job duties, employees turn to innovative solutions for communicating with each other, sharing documents, storing information, and so on. And there are, of course, information security risks related to this. And media reports that the number of cyber attacks have increased significantly in the last month, and we expect that they will continue to increase while the social distancing measures continue and life continues in more digital terms. In combination with the increased information security risks, there are generally less resources available on site to remediate information security incidents and manage the various aspects of such incidents, including reporting obligations vis-à-vis regulators and affected individuals. And this is challenging, in particular, for example, in the EU, where the GDPR provides for a 72 hours reporting time frame. So it's important to be aware of these challenges and, to the extent possible, prepare for them. So what steps should you consider in terms of preparation? Well, first of all, you may consider reviewing and, if necessary, updating the organization's information security policies in light of the increased cybersecurity risks related to remote working and processing of sensitive personal data in the context of the pandemic. With many and different kinds of devices connected to the company's network, which are all accessing and storing data for which the company is responsible, having in place state-of-the-art encryption technology and multi-factor authentication is also really crucial. Furthermore, if you have an incident response plan in place, you may consider testing it by conducting a tabletop exercise to make sure it's lockdown-proof. This will allow you to identify potential hiccups or gaps that are related to the specific context of remote working that we're in today. As employees are your first line of defense, it's also important to tell them about risks related to teleworking and remind them of the company's information security policies, as well as the procedures for reporting potential information security issues. A last point I want to mention in terms of preparing for cybersecurity challenges related to the COVID-19 lockdown situation is to think about which incident response related tasks may require physical presence and plan how those tasks will be managed promptly, taking into account lockdown measures. The next crisis management related topic we want to discuss is safe teleworking, and I will turn the floor to my colleague Anna now to guide us through the relevant legal issues there.
Thank you. I'll start by saying that teleworking is not something new, but it has never been used so extensively and centrally to address a global health crisis. Many companies were not ready for it. So at this time, it is important that Privacy Council work closely with the information security teams to make sure the company has the right IT audit and monitoring plan in place for secure teleworking. Second, employees need to know what is safe and what is unsafe use of IT systems when working remotely. You may have received emails from your company's management about it. You may have seen some references to teleworking and acceptable use policies, but now is the time to get things a bit more organized. So consider issuing concrete guidelines to employees with do's and don'ts for safe teleworking and explain the privacy and security risks in clear and simple language. I would say use signs where you can and keep everything in one place. Recently, one of the German DPAs issued relevant guidance on teleworking safety. The title of the guidance was, "And suddenly you're at home, now what?" And this is exactly the message that your teleworking guidance should explain to employees. So be clear about what you allow employees to do when they work from home, but also tell them what you require from them. And you can see some of these examples on this slide. Also, you will want to remind employees regularly to be mindful of COVID-19 phishing emails and that they should know who to contact to report the loss or theft of a company-owned device. The German guidance mentions also a few other things which are interesting. It suggests that employees should be mindful that others are not present when they take business calls from home, but each company should assess what works best for their teleworking policy. If your organization does not have a teleworking policy, you should consider developing one, or at least you should consider updating existing policies to address teleworking issues. It is now a good time to reflect on how things went in the first month of the lockdown and document any practices your organization has developed in a solid policy document, especially if you envisage that teleworking will stay and it will be widely used at your organization also after the lockdown measures have been lifted. Now, we would like to turn to the next topic and talk about best practices for vendor management. You probably have a vendor management program that includes privacy reviews of your vendor contracts and arrangements, but at this time, you may need to think more about continuity of your vendor program for the following months. So know your vendor. If you have not done so yet, consider mapping out the vendors that are critical to your business model, the vendors that your products and services cannot live without. In case of business emergency, you will need to know who is best placed to assist you. So list the relevant contact persons and their backup resources for each vendor faction that is critical. It may even be a good idea to list the relevant reporting lines of your vendor and know how to escalate things efficiently. In addition, try to anticipate issues that may arise in connection with the vendors that handle personal data on your behalf. Will they be able to delete personal data under the terms of your contract? What if they're facing resources issues? Will they be able to notify you of a personal data breach on time? At some point, you should consider reviewing agreements with key vendors and see what you have in place with them. If necessary, revisit data security and confidentiality arrangements or incident notification clauses to better protect your interests. In conclusion, you and your team should all know who to contact on important vendors in the event your direct contact person becomes unavailable during the pandemic. Be sure to maintain an appropriate contact list and share it with your team members to maximize efficiency in the event a vendor issue requires quick attention. Another key point is ensuring business continuity. As you know, Article 32 of the GDPR requires companies to implement technical and organizational measures that ensure the ongoing confidentiality, integrity, availability, and resilience of processes, systems, and services. In addition, security measures must be implemented to be able to restore the availability and access to personal data in a timely manner in the event of a physical or technical incident. This is what the law says. So what you need to do as Privacy Counsel is to make sure that your organization has an updated business continuity and disaster recovery policy, which takes into account the novel situation of COVID-19 and the issues that your organization is experiencing as a result of this. This may include addressing technical challenges that the company may be facing during the lockdown period, but also organizational issues regarding privacy procedures, availability of resources, and timelines for getting your security program back to normal. So what about the continuity of your overall privacy compliance program? In the last couple of weeks, maintaining your privacy compliance program maybe was not your priority, but you should not let GDPR compliance fall through the cracks. If you do not maintain your privacy program properly, you may face challenges that are more difficult to fix in the long run, such as damage to reputation and customer trust. Complaints from individuals are another risk to consider. People stay at home and have time to complain. It is unclear how enforcement of privacy regulators will evolve in the next month. Data protection authorities seem to understand that organizations are facing challenges while they need to divert resources and prioritize other areas. But for how long? It would be at least surprising that a regulator would not take enforcement action at all in the following months, in particular in cases of severe or intentional GDPR violations. Next up is organizing your resources. In this slide, we have prioritized the key accountability elements of a GDPR compliance program for which you should consider organizing your resources to ensure business continuity from a GDPR perspective. First, leadership and oversight. Consider mapping out who the business should contact for GDPR reviews of products and services. If key individuals or members of the privacy team, senior management, or the data protection officer become unavailable or have limited bandwidth to deal with an important data protection issue because of other priorities. Escalation processes. Do you have a plan of how any risky processing activities or decisions will be escalated internally? Perhaps you do, but it would be best to document the process and make sure everyone knows it. You might not need to define a new process specifically for the COVID-19 period. You might be able to leverage an escalation process that you already have in place, for example, in connection with your incident response plan. Also, think how you will be managing data protection impact assessments moving forward. This is relevant for DPAS regarding new products and services, and also DPAS regarding COVID-19 measures that your organization might take when people start going back to the office. So you should assess if you need to update your DPIA program to assign responsibilities and document all individuals who are best placed in terms of availability and knowledge of the company to perform and supervise DPIAs in the following months. Also, you should keep GDPR records of processing activities updated, especially if the company is introducing COVID-19 confinement measures, such as temperature tests or immunity tests. Last but not least, consider how data subject access requests will be handled. Identify primary and alternative resources who will be handling the requests during the COVID-19 situation and train them accordingly. In addition, consider if any steps in your response process require physical presence at the office and how you will address this issue. Now I would like to discuss the timeline for dealing with data subject requests in a bit more detail. The GDPR requires data controllers to respond to individuals' requests about their rights within 1 month of receiving the request. This deadline is the same for all GDPR rights, the right of access, correction, deletion, objection, or portability requests. In addition, the GDPR allows companies to extend this deadline by another 2 months, taking into account the complexity and the number of the requests. But the extension should be communicated to the data subject within the initial 1 month deadline, and it must state the reasons for the delay. We do not think that COVID-19 can be an excuse for extensions in relation to honoring opt-outs and objections to direct marketing activities, in particular with regard to sending marketing emails. Because once individuals opt out, they should no longer receive marketing emails, and this can't wait long. DPAs certainly have some degree of flexibility and understand that companies needed to prioritize other issues. But their message was clear. They cannot extend statutory timelines. So what should you do to respond to data subjects' requests without significant delay? Plan your extension strategy and use it with caution if it is necessary. Also, start documenting the reasons for which you might consider an extension while you are taking steps to gradually go back to your normal process. But do pay particular attention to your direct marketing program and how you comply with opt-out requests regardless of COVID-19. Before we close today's program, I would like to show you a list of the key privacy governance policies that may require a fresh-up as business continues in new terms in the following months. I will not go into details for each of these policies that you see on this slide, but this gives you hopefully a flavor of how to document internally the types of issues that we discuss in today's program. And with these thoughts, I'd like to close this presentation. Thank you.
Great. Thanks, Anna. And thanks, everyone, for joining our webinar today. You can follow our COVID-19 privacy updates on the Hunton Privacy blog and our firm's COVID-19 Resource Center. In the following days, we will also publish a detailed article on the issues we discussed today on our Resource Center. And you will also receive a link to download that article, if you like, when you receive the slides and the recording of today's program. Thanks again, and stay well and safe. Until next time, goodbye.